Hi, good afternoon. It's Scott Barnes here at Ward & Barnes Law Firm in beautiful and sunny Pensacola, Florida. As you can see, I've got Facebook pulled up on my screen back here, and that's because I want to talk to you about Facebook and how it interacts with personal injury litigation, which is exactly and pretty much exclusively what we do here at Ward & Barnes. And it's a question that a lot of my clients have, which is, will Facebook come into play in my personal injury case? And the short answer to that question is yes, usually it does. If you have Facebook, and I'm focusing today on Facebook, but all social media, Twitter, Instagram, maybe not Snapchat, that's a little harder for defendants to get, but as a general matter, all of your social media can come into play, and once you get into litigation in a personal injury case, the defendants can request a reasonable time frame of your Facebook profile or of your social media profile for them to look through that information. And sometimes clients ask me, well, why? Why are they entitled to it? And the short answer is that to some degree, many courts, especially in Florida, will allow a defendant to have a little bit of latitude to discover information about the plaintiff. You know, Facebook is a place where people put a lot of their lives and a lot of pictures and a lot of the activities that they're doing. So the argument that defendants will sometimes make to the court is that it can be very relevant in a personal injury litigation. Well, judge, these photographs may show the person being active when the person claims that they're hurt and they can't be active, things like that. And so a lot of courts have allowed defendants to get the entire Facebook profile of our clients for certain periods of time. And so that is something that we have to deal with frequently in cases, and we have to tell our clients, yep, you got to turn over this information. Now, just because it's discoverable, which means that in the process of the case itself, it has to be given to the other side, that doesn't ultimately mean it's going to be admissible at a trial. In order for the information to be admissible at trial, it has to be relevant to an issue with the case. And let me give you just a quick example. If you're in an injury case, let's say it's a motor vehicle case, and you're claiming a lot of injuries, and then there happen to be some photographs of you on Facebook doing backflips off a cliff somewhere after your injury. Well, that may be relevant, and the defendants may be able to use that to say that you're not really injured or as injured as you claim to be. On the other hand, if there's something on your Facebook profile that just makes you look kind of bad in some way, let's say maybe you had a late night out with friends and you drank too much and somehow some of that ended up on Facebook. Well, if that's not relevant to any issue in the case, the defendants can't just use that in a trial to sling mud. So while they might have gotten their hands on that in the discovery process of litigation at a trial, that won't necessarily be admissible. But those are all issues that have to be kind of sorted out depending on the particulars of your case, depending on your attorney, depending on the defense attorney, and of course depending on the judge and the state you live in. Now, in terms of tips, it's really tough to give specific tips, and I'll just kind of give you the tip that a carpenter would give you when it comes to cutting things. Carpenters a lot of times will tell you you should measure twice and you should cut once. And when it comes to Facebook or social media, I would say think once, think twice, maybe think 3 times, and then if you still want to post it and you don't think it's an issue, okay, maybe go ahead and post it. But just really try to stay away from living your minute-to-minute life on Facebook if you're in a personal injury litigation case. Thank you. Hope you guys have a wonderful day.